In 1994, Monica Lewinsky's name was not a household word, but the Conservative Caucus in 1994 launched a campaign for a congressional impeachment inquiry. And the reason we did that was because of our concerns about Clinton facilitating transfers of militarily applicable technology to communist China. And he provided exceptions for companies whose leaders had been major contributors to Clinton. And it took a while, but eventually, with the help of Congressman Bob Barr and others, we were able to secure an impeachment inquiry, which led to the impeachment of President Bill Clinton. He was not convicted in the Senate, and I wonder if Al Gore ever looked back and reflected on the likelihood that he would have been president if he had supported the effort to convict Clinton. But thank God we were not subjected to Al Gore in the White House. Well, in any event, one of the reasons I'm here is because of my hope that the Constitution Party, during the discussion of resolutions, will vote to join the coalition for a congressional impeachment inquiry with respect to Barack Hussein Obama. And thank you. And if there are others in this audience who head organizations, I would encourage you to consider having your organization ally itself with our coalition for a congressional impeachment inquiry. Now, let me share a few thoughts concerning impeachment with you. Here's what the U.S. Constitution says about impeachment. Quote, "The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors." George Mason, one of America's founding fathers, who prodded his colleagues to add a Bill of Rights to the Constitution, expressed the view that under British precedent, maladministration was itself an impeachable offense. But beyond maladministration, there are many reasons for Congress to explore possible grounds for the impeachment of Mr. Obama. One, there is new evidence that Obama was born in Kenya, not in the United States, not even in Hawaii. His failure to make available his supposed Hawaiian birth certificate should be explored by the House Government Oversight Committee. This is one of the reasons we need a congressional impeachment inquiry, so that the possibility that he did not qualify for the presidency as a natural-born citizen can be considered. Second, many elements of Obamacare are unconstitutional, including the requirement that every American must purchase health insurance, lest the IRS take action to confiscate part or all of any tax refund due to a U.S. citizen's failure to purchase a supposedly qualified insurance plan. In this connection, Obamacare funds 16,000 new IRS agents to help ensure that U.S. citizens obey. Obama's impeachable offenses also include the following. A, commandeering the state legislatures. Obamacare requires that states pay for much of the program. Judge Andrew Napolitano says this method of paying for Obamacare is clearly unconstitutional because it amounts to commandeering the state legislatures for federal purposes, which the U.S. Supreme Court has already ruled to be unconstitutional. Second, forcing citizens to buy a product. Obamacare attempts to force citizens under penalty of law to purchase health insurance. The Congressional Budget Office in 1994 offered this opinion on the constitutionality of such an idea, quote, "A mandate requiring all individuals to purchase health insurance would be an unprecedented form of federal action. The government has never required people to buy any good or service as a condition of lawful residence in the United States." To secure passage of Obamacare, Mr. Obama put out fraudulent budget numbers concerning its likely cost and impact on the deficit. In his State of the Union address, Obama claimed that the Congressional Budget Office had estimated that his approach to health care reform, quote, would bring down the deficit by as much as $1 trillion over the next 2 decades, unquote. But Obamacare does not start paying out most supposed benefits until 2014, even though it starts collecting taxes immediately. Thus, we face 10 years of taxes paying for 6 years of so-called benefits. Next, refusing to enforce the law on labor union accountability. Labor unions receive special favored treatment under Obamacare. Obamacare would no longer enforce laws requiring labor unions to report how they spend the dues of union members. Next, Obama's plan, or has a plan, to seize 10 million acres of land. Senator Jim DeMint, one of the best of the Republicans, uncovered a 21-page administration document wherein the president sets forth his plan to seize more than 10 million acres of oil and natural gas-rich land in the western United States by placing it under the so-called protection of the Department of Interior. This could be the first step in an Obama plan to build a massive government-owned and operated oil and natural gas company similar to what Venezuelan dictator Hugo Chavez has advanced. By the way, whenever you fill up your tank with gas, remember that Citgo operates for the benefit of Mr. Chavez in Venezuela. Constitutional scholars contend this is a gross abuse of the government's eminent domain power. Next, no supposedly democratic, and I use that word advisedly, country knowingly elects leaders to debase their country, give away power, bankrupt the Treasury, incorporate socialism, dissolve constitutional rights, cripple capitalism, and menace every citizen with reckless policies. Obama has done all these things, and I think we can fairly say that Mr. Obama is our first anti-American president. By the way, earlier today, discussion was made to his placing the United States under the microscope of a bunch of not-so-good governments at the UN to consider our human rights. And by the way, let me say that I publish twice monthly a newsletter called the Howard Phillips Issues and Strategy Bulletin, HPISB. If anyone here is not getting it and would like to get it at no cost or obligation, I'll send you some sample copies covering a great many interesting things. We go into great detail on Obama's interaction with the United Nations, and one of our lead stories recently talked about how Clinton, as president, had lost the codes which permit a response of nuclear weapons to an attack on the United States. Things like this you do not normally find in a newspaper. My staff and I scan 10 newspapers every day and dozens of magazines, and we pull out information which we think is very important to help you understand what's happening in the world, information which might otherwise escape your notice. And of course, one of his most egregious offenses was his refusal to enforce the law concerning homosexuals in the military. And I was glad to see the other day that the man that Obama chose to head the Joint Chiefs of Staff has come out against Obama's desire to facilitate the participation of homosexuals in the military. And I've got an article in my newsletter, which was just put in the mail, the headline of which is, "Macho Men Refuse to Bunk with Buggerers." And it goes into this, topic in some scientific way. According to a recent book called The Federal Impeachment Process, a constitutional and historical analysis written by Michael Gerhardt, impeachment is ultimately a political question which cannot be framed off a simple criminal analysis. The Legal Information Institute points out that, quote, "the process roughly resembles a grand jury inquest conducted by the House, followed by a full-blown trial conducted by the Senate, with the Chief Justice presiding," unquote. The established procedure is that the House Judiciary Committee, after deliberating about whether to institute an impeachment inquiry, adopts a resolution seeking authority from the entire House of Representatives to conduct such an inquiry. And approval requires a simple majority vote of those present. The Judiciary Committee would then conduct an impeachment inquiry, possibly through public hearings. And by the way, the new chairman of the Government Oversight Committee, Darrell Issa, has already indicated that he has some sympathy for proceeding with this type of inquiry. At the conclusion of the inquiry, articles of impeachment may be prepared. These must be approved by a majority of the committee, and it then goes to the full House, which would then consider and debate the specific articles of impeachment. And a majority vote of the entire House is required to pass each article. Once an article is approved, the president is, technically speaking, impeached. In other words, he becomes subject to trial in the Senate. This same book says, quote, "the major disagreement is not over whether impeachable offenses should be strictly limited to indictable crimes, but rather over the range of non-indictable offenses on which an impeachment may be based." In other words, the Judiciary Committee must determine what kinds of acts, which would not normally lead to an arrest, could still form a basis for impeachment. How are we doing on time, Jim? Raoul Berger, one of the greatest law professors and attorneys in our history, in his book, Impeachment, The Constitutional Problems, studied impeachment procedures occurring before the U.S. Constitution was written. He found the British viewed the process involving high crimes and misdemeanors as a category of political crimes against the state. Further, Professor Berger isolated, and I was privileged to know this great man, isolated the use of political in this sense and against the state as being identical in meaning. In essence, when the Brits called an action politically suspect, it was meant as an injury to the state. Blackstone, chronicler of the British common law, and by the way, Liberty Fund has just put out a tremendous set of books relating to the state of the law prior to the creation of the United States. He differentiates high treason from low treason, the latter being loyalty to an equal or a lesser. So high treason was disloyalty to a superior person or entity. The debates of the Constitutional Convention show at least that impeachable offenses were not limited to indictable offenses, but included offenses against the state. By the way, the Conservative Caucus is now doing a line-by-line analysis of the Constitution, harking back to the debates, not just at the Constitutional Convention itself, but in the state debates regarding ratification. I'm taping this analysis at the rate of about 90 minutes a day. We're ultimately going to cover the entire Constitution. It'll be up on the internet, and when we have it available, I'll let Jim Clymer know, And it's something I would encourage you to look at, because our author of these analyses, Charles Orndorff, a Phi Beta Kappa grad of the University of Virginia, is as knowledgeable on the U.S. Constitution as anyone I have ever encountered. Supreme Court Justice James Wilson, who was a constitutional signator, called impeachable offenses political crimes and misdemeanors. Harvard constitutional scholar and U.S. Supreme Court Justice Joseph Story wrote, quote, "The subject of impeachment is full of intrinsic difficulty in a government purely elective. The jurisdiction is to be exercised over offenses which committed by public men in violation of their public trusts and duties. These duties are in many cases political, and indeed in other cases to which the power of impeachment will probably be applied, the power partakes of a political character, political injuries to be of such kinds of misdeeds as particularly injure the Commonwealth by the abuse of high offices of trust." Justice Story said, quote, "No previous statute is necessary to authorize an impeachment for any official conduct." He went on to say that political offenses are of so various and complex character, so utterly incapable of being defined or classified, that the task of positive legislation would be impracticable if it were not absurd to attempt it. You may recall that Jerry Ford, as a member of Congress, pushed for the impeachment of Supreme Court Justice William Douglas, and at the time he said, "An impeachable offense is any offense that enjoys the support of a majority of members of Congress." Harvard Law School professor Lawrence Tribe, who was one of my Harvard classmates and who lived in my dorm, Eliot House, asserts in his monograph, American Constitutional Law, that a deliberate, quote, "a deliberate presidential decision to emasculate our national defenses or conduct a private war in circumvention of the Constitution must form the basis for non-indictable, impeachable action against the state." And if you look at the New START Treaty, which Mr. Obama and his subordinates negotiated with Moscow, it is a proposed treaty which does greatly weaken the United States and greatly strengthen the former Soviet Union. We need more votes to block ratification in the Senate, and I would encourage you to contact your senators to reject ratification. I could go on, but I don't want to abuse the time allotted me. If you support Obama, it means you want to revolutionize the U.S., but no democratic country, or republic, knowingly elects its leaders to debase their country, give away power, bankrupt the Treasury, incorporate socialism, dissolve constitutional rights, cripple capitalism, and menace every citizen with reckless policies. That would be ridiculous and anti-American, but Barack has done all these things. He must be impeached, and the way to begin is with a congressional impeachment inquiry. The Conservative Caucus is leading the push on this. There are other organizations already working with us in this coalition, and I hope that the Constitution Party will decide to join the coalition for a congressional impeachment inquiry, and that you will encourage any organization in which you exercise authority to do likewise. Thank you very much for your time. I appreciate it.